which I have a seat, the second jury.
All rise. The Summit County Court of Common Pleas is now in session. The Honorable Allison McCarty presiding. Thank you.
It is the court, this is the State of Ohio versus Kenan D. Ivery. It's case 2014-12-3681. Mr. Ivery is present in court this morning, represented by Attorney Harry O'Brien and Attorney John Bredin. Should he approach? Yes, sure. Your Honor, we are here for arraignment this morning on an 18-count indictment against Mr. Ivery. He has been served with a copy of that indictment.
Answer yes for the record.
Yes, he has, Your Honor.
Okay.
We acknowledge his receipt of the indictment from the prosecution.
All right. And we ask the Shirley then to go ahead and read the indictment to the defendant.
Thank you, Your Honor. Indictment type direct, case 2014-12-3681. Indictment for aggravated murder with a specification for death, with a firearm specification, and a second firearm specification under 2941.145. Murder, special felony with firearm specification, and a second firearm specification. Murder with firearm specification, second count, with firearm specifications. Felonious assault, F1 with firearm specification, second firearm specification. Attempted murder, felony 1 with a 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 firearm specification. Felonious assault, felony of the second degree with a firearm specification. Felonious assault, felony 2 with a firearm specification. Felonious assault, felony 2 with a firearm specification. Felonious assault, felony 1 with a firearm specification and second firearm specification. Felonious assault, felony 2 with a firearm specification, having weapons while under disability, carrying concealed weapons, felony 4. Illegal possession of firearm in a liquor permit premises, felony 3. Tampering with evidence, felony 3. In the Common Pleas Court of Summit County, Ohio, of the term of November, in the year of our Lord 2014, the jurors of the grand jury of the state of Ohio within and for the body of the county aforesaid, being duly impaneled and sworn, and charged to inquire of and present all offenses, whatever committed within the limits of said county, on their oath in the name and by the authority of the state of Ohio. Count 1. The grand jurors do find and present that Kenan D. Ivery, on or about the 16th day of November 2014, in the county of Summit, the state of Ohio, aforesaid, did commit the crime of aggravated murder, and that he did purposefully and with prior calculation and design cause the death of Justin Winebrenner in violation of section 2903.01a of the Ohio Revised Code, a special felony, contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. Specification 1 to count 1 is a specification for death, 2929.04a5. The grand jurors further find and specify that the aggravated murder was part of a course of conduct involving the purposeful killing or attempt to kill 2 or more persons by Kenan Ivery in violation of 2929.04a5 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. Firearm specification to count 1, firearm specification 2941.1412. The grand jurors further find and specify that Kenan D. Ivery discharged a firearm at a peace officer or a corrections officer while committing the offense in violation of Section 2941.1412 of the Ohio Revised Code, contrary to the form of the statute in such case may be provided and against the peace and dignity of the state of Ohio. Firearm specification 3 to count 1 is firearm specification 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated that he possessed the firearm or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 2. In the grand jurors of the state of Ohio within and for the body of the county of Summit, aforesaid on their oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan D. Ivery, on or about the 16th day of November 2014, in the county of Summit and the state of Ohio aforesaid, did commit the crime of murder, and that he did purposely cause the death of Justin Winebrenner, in violation of Section 2903.02a of the Ohio Revised Code, a special felony, contrary to the form and statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 2, firearm specification 2941.1412. The grand jurors further find and specify that Kenan D. Ivery discharged the firearm at a peace officer or a corrections officer while committing the offense in violation of Section 2941.1412 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 2 to count 2, firearm specification 2941.145. The grand jurors further find and specify that Kenan D. Ivery had a firearm on or about his person or under his control while committing the offense and displaying the firearm, brandished the firearm, indicated he possessed the firearm or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 3. In the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, under oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan D. Ivery, on or about the 16th day of November in 2014, in the county of Summit in the state of Ohio, aforesaid, did commit the crime of murder, and that he did cause the death of Justin Winebrenner as an approximate result of Kenan D. Ivery committing or attempting to commit felonious assault, an offense of violence that is a felony of the first or second degree, in violation of Section 2903.02b of the Ohio Revised Code, a special felony, contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 3, firearm specification 2941.1412. The grand jurors further find and specify that Kenan D. Ivery discharged a firearm at a peace officer or a corrections officer while committing the offense in violation of Section 2941.1412 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 2 to count 3, firearm specification 2941.145. The grand jurors further find and specify that Kenan D. Ivery had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made, provided and against the peace and dignity of the state of Ohio. Count 4. In the grand jurors of the state of Ohio within and for the body of the county of Summit, aforesaid, on their oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan D. Ivery, on or about the 16th day of November 2014, in the county of Summit and the state of Ohio, aforesaid, did commit the crime of felonious assault, and that he did knowingly cause or attempt to cause physical harm to Justin Winebrenner, a peace officer or investigator of the Bureau of Criminal Identification or Investigation, by means of a deadly weapon or dangerous ordinance in violation of Section 2903.11A2 of the Ohio Revised Code, a felony of the first degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 4, firearm specification, 2941.1412. The grand jurors further find and specify that Kenan Ivery discharged a firearm at a peace officer or a corrections officer while committing the offense in violation of Section 2941.1412 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 2 to count 4, firearm specification, 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 5. And the grand jurors of the state of Ohio within and for the body of the county of Summit aforesaid, on their oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and state of Ohio aforesaid, did commit the crime of attempted murder, and that he did purposely engage in conduct that, if successful, would constitute or result in the offense of murder, to wit, to purposely attempt to cause the death of David Lopte in violation of Section 2903.02a/2923.02 of the Ohio Revised Code, a felony of the first degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 5, firearm specification, 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 6. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and in the state of Ohio aforesaid, did commit the crime of attempted murder, and that he did purposely engage in conduct that, if successful, would constitute a result in the offense of murder, to wit, did purposely attempt to cause the death of Jennifer Imhoff in violation of Section 2903.02a/2923.02 of the Ohio Revised Code, of the felony of the first degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 6, firearm specification, 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 7. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and the state of Ohio aforesaid, did commit the crime of attempted murder, and that he did purposely engage in conduct that, if successful, would constitute or result in the offense of murder, to wit, did purposely attempt to cause the death of Michael Cates in violation of Section 2903.02a/2923.02 of the Ohio Revised Code, felony of the first degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 7, firearm specification, 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made, and provided and against the peace and dignity of the state of Ohio. Count 8. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and the state of Ohio aforesaid, did commit the crime of attempted murder, and that he did purposely engage in conduct that, if successful, would constitute or result in the offense of murder, to wit, did purposely attempt to cause the death of Thomas Russell in violation of Section 2903.02a/2923.02 of the Ohio Revised Code, felony of the first degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 1 to count 8, firearm specification 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 9. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and the state of Ohio aforesaid, did commit the crime of attempted murder, and that he did purposely engage in conduct which, if successful, would constitute or result in the offense of the murder. To wit, did purposely attempt to cause the death of David Eitzel in violation of Section 2903.02a/2923.02 of the Ohio Revised Code, a felony of the first degree, contrary to the form of the statute in each case made and provided against the peace and dignity of the state of Ohio. Specification 1 to count 9, firearm specification 2941.1412. The grand jurors further find and specify that Kenan Ivery discharged a firearm at a peace officer or a corrections officer while committing the offense in violation of Section 2941.1412 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Specification 2 to count 9, firearm specification 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 10. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and state of Ohio aforesaid, did commit the crime of felonious assault, and that he did knowingly cause or attempt to cause physical harm to David Lope by means of a deadly weapon or dangerous ordinance in violation of Section 2903.11a2 of the Ohio Revised Code, a felony of the second degree, contrary to the form of the statute in such case made and provided against the peace and dignity of the state of Ohio. Specification 1 to count 10, firearm specification 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 11. The grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the County of Summit, the State of Ohio, aforesaid, did commit the crime of felonious assault, and that he did knowingly cause or attempt to cause physical harm to Jennifer Imhoff by means of a deadly weapon or dangerous ordinance, in violation of Section 290311A2 of the Ohio Revised Code. A felony of the second degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Specification 1 to count 11, firearm specification 2941.145. The grand jurors further find and specify that Kenan D. Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense, in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Count 12. And the grand jurors of the State of Ohio within and for the body of the County of Summit aforesaid, on their oaths in the name and by the authority of the State of Ohio, do further find and present that Kenan D. Ivery, on or about the 16th day of November 2014, in the County of Summit, the State of Ohio aforesaid, did commit the crime of felonious assault, and that he did knowingly cause or attempt to cause physical harm to Michael Cates by means of a deadly weapon or dangerous ordinance, in violation of Section 290311A2 of the Ohio Revised Code, a felony of the second degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Specification 1 to count 12, firearm specification 2941.145. The grand jurors further find and specify that Kenan D. Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense, in violation of Section 2931.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Count 13. And the grand jurors of the State of Ohio, within and for the body of the County of Summit aforesaid, on their oaths, in the name and by the authority of the State of Ohio, do further find and present that Kenan D. Ivery, on or about the 16th day of November 2014, in the County of Summit, the State of Ohio aforesaid, did commit the crime of felonious assault, in that he did knowingly cause or attempt to cause physical harm to Thomas Russell, a peace officer or investigator of the Bureau of Criminal Identification and Investigation, by means of a deadly weapon or dangerous ordinance, in violation of Section 290311A2 of the Ohio Revised Code, a felony of the first degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Specification 1 to count 13, firearm specification 2941.1412. The grand jurors further find and specify that Kenan D. Ivery discharged a firearm at a peace officer or a corrections officer while committing the offense, in violation of Section 2941.1412 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Specification 2 to count 13, firearm specification 2941.145. The grand jurors further find and specify that Kenan D. Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense, in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Count 14. And the grand jurors of the State of Ohio, within and for the body of the County of Summit aforesaid, on their oaths and in the name and by the authority of the State of Ohio, do further find and present that Kenan D. Ivery, on or about the 16th day of November 2014, in the County of Summit, the State of Ohio aforesaid, did commit the crime of felonious assault, in that he did knowingly cause or attempt to cause physical harm to David Eitzel by means of a deadly weapon or dangerous ordinance, in violation of Section 2903.11A2 of the Ohio Revised Code, a felony of the second degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the State of Ohio. Specification 1 to count 14, firearm specification 2941.145. The grand jurors further find and specify that Kenan Ivery had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense in violation of Section 2941.145 of the Ohio Revised Code, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 15. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November, 2014, in the county of Summit and state of Ohio, aforesaid, did commit the crime of having weapons while under disability, and that he did without being relieved from disability as provided in Section 2923.14 of the Ohio Revised Code, knowingly acquire, have, carry, or use any firearm or dangerous ordinance, and was convicted of a felony offense involving illegal possession, use, sale, administration, distribution, or trafficking in any drug of abuse, in violation of Section 2923.13A3 of the Ohio Revised Code, a felony of the third degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 16. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths, in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and the state of Ohio aforesaid, did commit the crime of carrying concealed weapons, in that he did knowingly carry or have concealed on the person's person or concealed ready at hand a handgun other than a dangerous ordinance. Said deadly weapon being a firearm that was loaded or for which ammunition was ready at hand, in violation of Section 2923.12A2 of the Ohio Revised Code, a felony of the fourth degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 17. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and state of Ohio aforesaid, did commit the crime of illegal possession of a firearm in liquor permit premises, in that he did possess a firearm in any room in which any person is consuming beer or intoxicating liquor, in a premises for which a D permit has been issued under Chapter 4303 of the Ohio Revised Code, or in an open-air arena for which a permit of that nature has been issued, and did knowingly carry or have a firearm concealed on the offender's person or concealed ready at hand in violation of Section 2923.121 of the Ohio Revised Code, a felony of the third degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Count 18. And the grand jurors of the state of Ohio, within and for the body of the county of Summit aforesaid, on their oaths and in the name and by the authority of the state of Ohio, do further find and present that Kenan Ivery, on or about the 16th day of November 2014, in the county of Summit and state of Ohio, aforesaid, did commit the crime of tampering with evidence, and that he did, knowing that an official proceeding or investigation is in progress or is about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation, in violation of Section 2921.12A1 of the Ohio Revised Code, a felony of the third degree, contrary to the form of the statute in such case made and provided and against the peace and dignity of the state of Ohio. Signed by Prosecutor Sherry W. Walsh, Prosecutor General.
All right, and then just for the record, it was also signed by the grand jury as well.
Correct. Via true bill.
Having been notified and called upon the reading of the indictment in this case as to the charges presented here today, how does the defendant plead?
Your Honor, Mr. Ivery pleads not guilty to all counts and specifications contained in the indictment.
And then also for the record, Mr. O'Brien, I know you were appointed as first year counsel at the Akron Municipal Court, and you are certified, just for the record, I'm just required to ask you, you are certified to serve first chair in a capital case, is that correct?
That is correct, Your Honor.
And then, Mr. Brevin, you and I spoke yesterday. I believe you are also qualified to serve as first year counsel but you have agreed to serve as second-tier counsel in this case, is that correct?
Correct on both counts.
All right, so the court has appointed you to serve second-tier on this matter. Has your discovery motion been filed?
Your Honor, it's going to be filed this afternoon. I have been in contact with Mr. Loprenzi about the discovery process, and Ms. Shookey's indicated that that process has already begun in her office.
So then upon the filing of the motion, the nature of the party begin engaging in the discovery. And just for the record, what is the bond that is currently set for?
Judge, it's my understanding there is no current bond set for the defendant. We're asking that that order be continued.
Any wish to be heard on that matter?
No, Your Honor. In light of the fact this is a death penalty case, I don't think the issue of bond is appropriate at this time.
So the court will order that the defendant shall remain held without bond. So I was thinking we would set the first pretrial up approximately 30 days to give us some time to review the discovery.
It's fine, Your Honor.
And that's by agreement of the parties as well on that. I was thinking Wednesday, January 21st at 9 a.m. In other words, an off Monday.
Yeah. I have a trial set all January.
Okay.
It's going to be hard to pick a date.
So, well, I did a trial too, so
Right.
I'm thinking in the morning.
No, I think that's fine.
Or anything else.
Judge, in light of the fact that I have the same situation, quite a few trials set in January, might we set this matter at 8:30?
Yeah, okay, that's fine. All right, we'll set it at 8:30 on Wednesday, January 21st. And then the other thing I wanted to inquire just about a couple of things. The court has not, hasn't spoken to the parties about this matter, but I want to make sure I'm clear on the status of the defendant. Did he receive some medical treatment at the time that he was arrested? Did he have to go to the hospital and receive some medical treatment?
That's my understanding, Your Honor. There was a dog bite, and he received treatment here in Akron, and then he received subsequent treatment in the Summit County Jail and further treatment, I believe, in the Medina County Jail.
And I'm just inquiring, is there any issue with that, or does Mr. Ivory feel that he was adequately, that medical situation has been resolved?
Mr. Ivory has not made any mention of it in the last few weeks, Your Honor.
Okay. And then the only other thing is when we meet back on the 21st, I realize it's only the first pre-trial, but just because of the nature of everyone's schedules, I'd like to be able to at least preliminarily start talking about a case management schedule and possibly consider setting some dates for at least issues on investigators, experts, that kind of thing. So,
We'll be prepared on the 21st to discuss all those issues, Your Honor.
okay. Is there anything else?
Judge, are you also granting the defendant leave to challenge the indictment in piece of wishes by a certain date?
Yeah.
Your Honor, I raised that issue with Mr. Loprenzi in the past, so we would ask 7 days to be able to file that.
It's fine, I'll bring that.
Thank you. The other thing we'd like to bring up, Your Honor, is for Mr. Ivory's protection, he's been housed in the Medina County Jail. We would ask that to continue.
I know that sometimes the Summit County Jail does, as a courtesy, ask to, contiguous counties to hold prisoners. So the court has no objection to continuing that. That's within the discretion of the sheriff. So
We understand, Your Honor.
his decision. All right? Okay, we'll make sure that we get a copy transfer notices out for the hearing on that.
Understood, Your Honor. Thank you.
Thank you, Judge.
All rise.